Good afternoon, everyone, and welcome to the webinar, Alcohol-Facilitated Sexual Assault: Who Needs Force When You Have Alcohol, Part 1. My name is Cynthia Hatchell. I'm the project coordinator at Equitas, and I will be moderating today's webinar. Next slide. Equitas's mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. Next slide. As a national training and technical assistance provider, Equitas develops resources, conducts trainings, and offers 24/7 consultations for prosecutors and allied professionals. For more information on Equitas, please visit our website at equitasresource.org. Next slide. You can also follow Equitas on Twitter, Facebook, Instagram, and LinkedIn. The link to each is available on our website. Next slide. Today's webinar is supported by the U.S. Department of Justice, Office of Violence Against Women. The information presented in this webinar does not necessarily reflect the views of the Office of Violence Against Women. Next slide. Presenting our webinar today are Equitas attorney advisors Jonathan Kerlin and Patricia Powers. As an attorney advisor at Equitas, Jonathan presents on trial strategy, legal analysis, policy, and ethical issues related to gender-based violence. He conducts research, develops training materials, resources, and publications, and provides case consultation and technical assistance for prosecutors and allied professionals. Prior to joining Equitas, Jonathan worked for 16 years as a prosecutor in the District Attorney's Office in Berks County, Pennsylvania, serving as Chief Deputy District Attorney, Chief of Trials, and Assistant District Attorney. During his time in the Berks DA's office, he prosecuted and supervised prosecutions involving intimate partner violence, sexual violence, child abuse, and fatalities, stalking, child pornography and exploitation, child abuse and molestation, and human trafficking. Jonathan has extensive experience working with multidisciplinary partners, including victim advocacy and medical professionals. He served as the office representative for the STOP program, multidisciplinary investigative teams, and other community-based collaborative efforts. As an attorney advisor at Equitas, Patricia presents on trial strategy, legal analysis and policy, and ethical issues related to the prosecution of intimate partner violence, sexual violence, and stalking. She also conducts research, develops training materials, resources, and publications, and provides case consultation and technical assistance for prosecutors and allied professionals. Prior to working with Equitas, Patty served as a senior deputy prosecuting attorney and supervising attorney with the Sexual Assault Domestic Violence Unit in Yakima County, Washington. During her 27 years as a trial attorney, Patty focused primarily on sexual assault, domestic violence, and child and adult homicides, including complex litigation of high-profile and cold cases with frequent use of expert testimony. I will now turn it over to Jonathan Kerlin and Patricia Powers.
Hi, this is Patty Powers. I'm happy to join with my colleague, John Kerlin, in discussing a major area of our work as prosecutors. Before we delve into this area of alcohol-facilitated sexual assault, we'd like to make the following acknowledgments that you now see on the screen. All of the individuals featured on this screen have provided immeasurable support and expert insight, and their work is truly appreciated. As you can see, this is part one of our webinar series. In this part, we're going to be focusing on law as relevant, toxicology, investigating and collecting evidence, and also offender behavior. The second part of this series will be featured on May the 20th, and this will involve interviewing victims, getting ready for trial, continuing collaboration with allied professionals, as well as trial. As I mentioned earlier, we're going to be focusing on alcohol-facilitated sexual assault. And initially, I'd like to share that if ever there was a theme for these cases, it's who needs force when you have alcohol. And this theme is going to take on even more significance as John and I develop material through this webinar. It begins, though, with our objectives, the infrastructure for our work as prosecutors with drug and alcohol facilitated sexual assault is collaboration with experts to ensure our understanding of measurement and analysis of intoxicants or perhaps even prescription medications that may be present in the victim's body during the critical time of the sexual assault. Or in some instances, we may wish to collaborate with experts to help explain the perhaps unanticipated absence of intoxicants or medicine. We all know that sexual assault is a crime that is premeditated. It is planned to some extent in advance of the actual crime. Especially with alcohol-facilitated sexual assault, we need to take a deep dive into the evidence of predatory conduct to understand how the offender was able to commit the crime. And collaboration with allied professionals is key to our depth of understanding of this evidence, and it also enables us as prosecutors to develop a victim-centered approach to our work while maintaining laser-like focus on the offender's role and the offender's accountability. So this is the question that's going to be at the center of John's and my efforts today. What is drug or alcohol-facilitated sexual assault? And the answer is going to come in a number of different circumstances, but it comes down to this. The victim is too intoxicated to consent due to one of these alternatives, and many of these are already incorporated into our statutory references. We have one option of surreptitious administration by the assailant. The perpetrator drops a drug or introduces an unknown drug into a drink that the victim may be asked to consume. There may be voluntary use of alcohol by the victim, but I want us to be careful in this area because what may appear to be voluntary may actually be coerced by an offender. So perhaps we should have quotation marks around voluntary to really invite our deeper scrutiny into this aspect of our evidence. And sometimes a victim may be too intoxicated to consent due to a combination of both, using intoxicants knowingly or unknowingly, or perhaps an offender surreptitiously administering an unknown substance. And the question that probably all of us who are participating today can answer is, how common is alcohol-facilitated sexual assault? All of us present and participating in this webinar know from our own experience as prosecutors how very common this crime is. This is information from Antonia Abbey, and what she is telling us in terms of her work in researching is that for young adults, almost 1/2 of reported cases took place while the victim is under the influence of alcohol. Now, this does not mean by any means that a victim who is drinking somehow is responsible for a sexual assault. That's not the point. But as we all know, offenders oftentimes will sexually assault individuals who are accessible to them. And how much more accessible can a person be when that person is with an offender on a date or involved in some kind of a social setting, as an example. The second component of that formula is vulnerability. If a person is drinking and is affected or is under the influence of alcohol, that's a significant feature of vulnerability. The third component of that formula is the offender's conception of credibility, not ours at all, but how an offender views a victim who may be drinking, thinking that somehow maybe that person will not have high credibility. The second component of Antonio Abbey's study is approximately 1/2 of all sexual assault cases are committed by men who have been drinking alcohol. And we all know as prosecutors, this is not an excuse, because in many instances, a person has to work harder to commit a crime when impacted or affected by alcohol. But oftentimes, in our experience as prosecutors, we know that offenders can use or try to use their consumption of alcohol as cover for their conduct. This screen, which is from an earlier period of time, just gives us a basic understanding of the prevalence of intoxicants used in sexual assault cases. As you can see, alcohol is substantially prevalent. There's no question about it. I also would suspect that opiates, as well as other drugs that are seen on this screen from a much earlier time, would also be significantly higher. But this just reflects the prevalence of intoxicants that are used very frequently in sexual assault cases. What makes alcohol-facilitated sexual assault and drug-facilitated sexual assault cases challenging? I wish we had an opportunity to talk directly with all of you now who are participating, because we've all been involved in these cases and are very familiar with a number of challenges. So the question associated with this is, why are these cases not always reported? Now, we need to recognize at the beginning that many times victims are unable to report because of the impact of trauma. That certainly is a reason. We know sometimes a victim can be embarrassed because of drinking, or maybe drinking to excess, may even feel some guilt for being in that circumstance and engaging in alcohol consumption. Many times victims can simply disbelieve or not be able to cope with what happened. I can't believe that this happened to me. And sometimes memory can be impacted or affected. But what's very important for all of us to remember is, even though a victim's memory can be impacted by alcohol, trauma is still on board. And this is critical in terms of our work as prosecutors to recognize that reality. So we go back to the question, the theme of John's and my presentation today: alcohol's facilitated sexual assault, or who needs force when you have alcohol? And what we're going to be talking about as we develop material in this webinar is how offenders have this information. They know that force is not required. They also know that they don't need to leave injuries in the application of force, and that those injuries could even constitute evidence. So what we're looking at is also how the offender views the consumption of alcohol, and how the offender will engage in strategies to facilitate alcohol-facilitated sexual assault without even needing force. We're going to turn now to proving the crime, and all of us who are involved in this presentation and are participating have statutes which give us the elements of the crime that, as prosecutors, we know that we need to prove beyond a reasonable doubt. So we're going to turn to this area now and focus on means of strengthening our investigations and building our cases. There's a two-step analysis that we engage in, and this is something that we do as prosecutors when we're basically even trying to reach a charging decision. We assume the veracity of the victim's disclosure. And looking at that disclosure, we try to determine whether or not the information that the victim is able to provide constitutes a crime, a crime of rape under our statutes. The second part of our analysis is, given the disclosure and the allegations that are made, can we prove these allegations beyond a reasonable doubt with evidence that we're able to develop in our investigations? Step one, is it rape? What we do as we begin to analyze the victim's disclosure, we're in the background, we have our own statutes, and we need to review those statutes that cover sexual offenses. What sex acts are covered? What acts of penetration are covered in our jurisdictions? Is force required? And if it is, what kind of force is required? Or is it not required in certain kinds of cases? And in some cases of alcohol-facilitated rape, we're very clear that force may not be required in some sections of our statutes, particularly when a victim is substantially incapacitated or impaired. How is consent defined in our statutes? We all know, particularly if a victim is substantially incapacitated, maybe passed out, a victim is not able, is in no position whatsoever to consent. But how do our statutes reflect what is necessary for consent? In many jurisdictions, there are separate statutes that are specific to alcohol-facilitated sexual assault, and we need to take a look at those in terms of our analysis. How many times have we heard this? But he was drunk too. So why isn't it just drunk sex? Isn't his intoxication a defense? And I know, even though we can't all hear each other, I know there's a resounding no that's emanating from all who are participating in this conference. This is probably one of the most frequent defenses utilized by defendants, in addition to the consent defense. I just didn't know what I was doing. I felt like something, like she wanted to be involved with me. I think it was pretty clear, but it was just one of those things. I was pretty drunk too. It does not allow an offender to escape accountability, as we all know. We know that rape in most of our jurisdictions is usually a crime of general intent. And in most statutes, a showing of intent is actually not necessary. Voluntary intoxication also is not a defense when we don't have a crime of general intent. So a defendant's claim of voluntary intoxication is usually not going to lie or be appropriate in this kind of a case. What we want to do, though, is to compare this with other crimes in our jurisdictions where intoxication is allowed as a defense. I know in many of our jurisdictions, if extreme intoxication under case law can actually allow sometimes a claim of diminished capacity. We need to be familiar with those other areas. As prosecutors, we need to prove that the defendant knew that the victim was incapacitated or unable to consent. And what's really important about our analysis in this area is, even though rape is not a crime of intent or a general intent crime, we also have to make sure that we're really delving into the evidence, because if we have a drunk sex claim, it may be possible that jurors will try to speculate, if you will, into a lack of intent. So even though this is not necessary to establishing the elements of the crime beyond reasonable doubt, we need to be aware that in some instances, it may subtly affect a juror's consideration of our evidence. If you have questions in this area, we really hope that you'll reach out to us at Equitas. We have a comprehensive compilation of state statutes as well as analysis, and we'd be delighted to share that with any of you. The second step, and we talked about this earlier, now that we have accepted the information that the victim has provided, we've consulted with our statutes, the next question for us as prosecutors is, can we prove the rape, the elements of the crime, beyond a reasonable doubt in a court of law? This graphic illustrates the comparative difficulty of proving disclosures of sexual assault in the context of alcohol and drug facilitated sexual assault. In general, in many cases where there is a sexual assault by using force or a threat of force, there's not really the same kind of difficulty, ostensibly, as when we have a victim who is unconscious or a victim who is substantially incapacitated and basically does not have the capacity or ability to consent. So this shows us what the comparative difficulty is. And it's important to reflect upon this because depending upon the kind of evidence that we have, we know that we're going to be challenged in these areas, but we also have access to information and strategies that can allow us to meet this challenge of comparative difficulty. And what we're going to do initially is to look at the totality of circumstances. Just to use a simple analogy that we're all familiar with, if we take a rock and drop it into a pond or a stream, those ripples go out for some distance in that pond or stream. We need to broaden our investigations and we need to broaden our perspective as prosecutors to look at the entirety of the context, to focus on the totality of circumstances. That means conduct before, conduct leading up to the sexual assault itself, and the aftermath of the sexual assault. All of this perspective is going to give us critical means of recreating the true reality of this crime, eventually for a jury. So we're going to turn now to toxicology and the impact of alcohol and drugs on the body. The first question is, as prosecutors, how do we benefit from toxicology? And I'm sure right now, as you're all considering this question, you're thinking of a number of different ways that it could benefit us. These are a few of them shown on this slides. We need to know toxicology, which we're going to be discussing in just a couple of slides, because it helps inform us to make reliable charging decisions. We need to know about the drugs that were present in the victim's body at the time of the sexual assault and how that impacted a victim in terms of conduct, in terms of understanding or appreciating the nature of danger that she or he may have been in. It helps us to understand the victim's disclosure. There may or may not be some missing aspects to that disclosure based upon the impact of trauma and also sometimes the impact of alcohol. This kind of understanding is also going to enable us to connect jurors with the true reality of that crime. We can really get into more analysis of offender behavior if we understand the impact of toxicology and come to understand how the offender was seeing the victim, given what her or his state of alcohol involvement was. It enables us to collect evidence, to ask appropriate questions of victims during interviews, to understand information that offenders may provide. It helps us to provide a true victim-centered approach to our work as prosecutors, to understand traumatic responses both during the crime of sexual assault as well as afterwards, And as prosecutors, we also want to be in a position to proactively combat defenses that we know that are going to occur.
So I think this is where I jump in, and I want to thank my colleague Patty Powers for setting the table so well, and Cynthia Hatchell for moderating and helping us with all the technical aspects. So in terms of setting the table, Patty's described really well, or hopefully caused a lot of anticipation for everyone in our audience today, about what a great tool in understanding toxicology can be when we as prosecutors are looking to investigate and prosecute AFSA, alcohol-facilitated sexual assault cases, and drug-facilitated sexual assault cases. And so trying to get this layperson's understanding of toxicology is essentially what we're going to be doing for about the next 30 slides or half hour or so. Before we really dive in, I want to, of course, give the caveat, my background is as a lawyer, not as a toxicologist, so that limitation should be expressed. I also really want to refer back to the acknowledgments slide that Patty read way in the beginning, and a lot of the information and understanding is informed by the great work of Jen Summers from the New York Attorney General's office, who actually is not only a fantastic prosecutor, but also has training as a toxicologist, and Mark LeBeau. Certainly anything in here that is misstated is attributable to me and not to those two professionals who do such great, wonderful, and consummate work. So some basic premises of toxicology that we should understand with alcohol-facilitated sexual assault. And that is this, is that alcohol, how it acts as an intoxicant is that it is a central nervous system depressant. Which essentially has a similar effect on your body that when you go under anesthesia for surgery. What central nervous depressants do is they impair cognition and psychomotor skills. And the other premise to keep in mind before we start scaffolding these basic premises is that as consumption increases, alcohol progressively impairs bodily functions and abilities. Now, part of this impairment of cognition and psychomotor skills, this can lead to impairment of memory and cause gaps in memory. But I do want folks to note very carefully, one thing that's not included as an impact or effect of alcohol is that alcohol is not a hallucinogen. While it might cause difficulties or challenges in remembering, it doesn't create false memories. So essentially, if you have victims that can clearly remember not consenting, that's very unlikely to be manufactured or less credible because of alcohol intoxication, because that wouldn't be imagined. There might be gaps in remembering what was done or not done, but what is remembered is not inherently incredible because of the alcohol consumption. So alcohol as an intoxicant, what causes it? Well, the thing that causes it, alcohol as an intoxicant, is ethanol. That's the chemical name for it. And the intoxicating effect of ethanol is the only difference with it in different kinds of alcoholic beverages. It happens in terms of concentration. But the impact and effect on a person's body, it doesn't differentiate by the type of alcoholic drink. What it means is the higher the concentration of alcohol in the beverage, then the more rapidly blood alcohol content can be spiked and raised. And here on the left side of the slide, we see some sort of standard or average percentage by volumes of ethyl alcohol in various beverages. Want to be careful or cautious though, especially with something like beer. The average here is indicated as somewhere between 4 to 6% of ethanol by volume. That might be a little bit low if we're dealing with IPAs and things like microbrews and issues like that. That might actually be a little bit higher. The other thing we want to keep in mind is we discuss the impact or sort of the average impact of number of drinks as it in fact impacts blood alcohol level. That's based on a standard drink size, which is laid out here. And you see some examples of it, a 12-ounce beer, 4-ounce wine, 1-ounce 100-proof liquor. Those are basically serving sizes that are estimated or utilized for laboratory settings. And when we're talking to our victims and working with our victims and witnesses, and when we ask how much someone had to drink, and they said the person had 2 or 3 beers, don't always assume, like think in a sort of a clinical fashion, well, that was 2 or 3 12-ounce beers, because it's really unusual or uncommon if we're in restaurants or if we're out that we have just a 12-ounce cup instead of a 16-ounce cup. The 1-ounce shot is, there's not a lot of bartenders that give you just 1 ounce. They usually fill the shot glass to the brim. So when we're asking people about how much, when they can be quantified, how much someone had to drink, keep in mind that it could actually be underestimated in terms of drink size and quantity sizes. So another thing we need to understand, and we want to talk about for an understanding of toxicology, is getting an understanding of how and where alcohol is absorbed into the body. And the reason why understanding how alcohol is absorbed into the body is because the more quickly, understanding absorption is important because a faster absorption of alcohol is going to mean, generally speaking, higher BAC level and a higher rate of intoxication and impairment. A more gradual level of consumption or of absorption is going to mean a lower blood alcohol level and then a lower rate, a lower rate of impairment. And so these are the sorts of things we want to understand. Where alcohol physiologically is going to be absorbed in the body, up to 2% is going to be absorbed through the mouth. Up to 20% is going to be absorbed through the small intestine. So if you had a case where someone just kept a mouthful of alcohol swishing through their mouth for a long period of time, that would lead to very gradual rates of increase in BAC and lower levels of impairment. But of course, most alcohol doesn't spend much time in an individual's mouth. It goes on to the stomach and to the small intestine. Now we want to understand about the small intestine. This is the primary absorption point for alcohol and pretty much for a lot of other things that we consume. And part of the reason is because while our small intestine is all coiled up in the body, as you may have sort of recognized from health class in the graphic earlier, the small intestine stretched out really covers a lot of surface area. Once alcohol is absorbed into the blood then through a small intestine where it can be absorbed more quickly into the blood, it then circulates throughout the body. Now, average absorption rate, and it's what we want to remember, and this is when we're talking about those standard sizes we talked about that might only have limited kind of real-world applicability, but the average time it takes for 100% of the alcohol contained in 1 beer, 1 glass of wine or spirit to be completely absorbed into the blood is about 30 minutes. This is all other factors being equal. However, as we're going to discuss, there's going to be a lot of factors or variables that can impact this absorption rate based on how much is being drank, the rate at which alcohol is being consumed, and other factors as well. Now, this rate of absorption that's ultimately going to help inform our level of impairment can be impacted by a variety of factors, such as food, body size, amount and type of alcohol, duration of drinking, fatigue, what someone's tolerance rates are, whether they're an experienced drinker or inexperienced drinker, or whether they're combining alcohol with other drugs. Essentially, how these absorption variables can impact alcohol, how these variables can impact alcohol absorption is if there has been food, then alcohol can be absorbed more slowly or more gradually. The bigger the body, then the more gradually it can be absorbed. The less concentrated the alcohol, the more gradually it can be absorbed. If there's a defined duration of drinking, it can be absorbed more efficiently. If someone's tired, it's probably going to be absorbed more quickly. Now, in terms, think of these factors. In alcohol-facilitated sexual assault cases, I don't want to say that they happen just on college campuses. They can happen in a variety of contexts. Recipe for basically alcohol being absorbed really high. People are usually going to have smaller body sizes, or smaller and maybe not as big as when you get to my age. There's usually going to be erratic food habits. Drinking usually starts later at night, when you're a bit more tired. There's more binge drinking, and especially with younger class people, there's probably going to be lower tolerance rates and more experimenting. This makes for an environment rife with people who may be more vulnerable from alcohol consumption and being intoxicated. Now, we're going to be talking about drug-facilitated sexual assault, but in terms of impairment, one of the things we want to remember is that combining alcohol with drugs is that it can have a synergistic effect. And what we mean by that is that the interaction of two or more substances or other agents can produce a combined effect that is greater than the sum of their separate effects. So what we mean by that is taking alcohol with another drug or a controlled substance of some kind. You don't just add those impacts together, and the impacts don't necessarily cancel one another out, but they can compound and multiply the effects the intoxicating effects that each of those substances have, which makes it even a lot more challenging to figure out someone's clinical level of impairment or intoxication, but sometimes can make it easier for us as prosecutors to help explain and help folks understand the accessibility of a victim and the vulnerability of a victim to alcohol-facilitated or drug-facilitated sexual assault. Now, turning back to physiology of the body and how alcohol is absorbed, we talked about food being a factor in the absorption of alcohol. And this is one of the reasons is because some of the biology connected with the stomach. If there's an empty stomach without any food, then alcohol is going to reach or get into the small intestine faster. And you remember that chart we showed a few slides ago. Once alcohol gets into the small intestine, where the majority of alcohol is going to be absorbed through the body, alcohol is going to be absorbed much more quickly, and that BAC is going to spike up more quickly. The longer alcohol can stay in the stomach and is absorbed through the stomach, then the more gradual process it is before it enters the bloodstream and reaches the brain and the impairment process begins. So if there's a full stomach, it can delay the time it takes for alcohol to reach the small intestine. And the reason for this is a little piece or part of the stomach called the pyloric valve, and that regulates entry into the small intestine. And if you have food in your stomach, that pyloric valve is going to stay closed while your stomach breaks down food into substances that can then be utilized or digested through your small intestine. If there's not food in your stomach, then that pyloric valve remains open, and beverages or liquid that then pours into your stomach doesn't stay in your stomach, it goes right into small intestine. Now, if you're having alcohol on an empty stomach, that means none of the alcohol is going to stay in your stomach to be absorbed at that essentially 20% rate. It's all going to the small intestine with that large surface area where it's going to enter the bloodstream a lot more quickly, and that impairment is going to be setting in. And here's a graph that sort of illustrates that, talking about rates of absorption and alcohol concentration and time on an empty stomach versus on a full stomach. This is why one of the reasons when we're meeting with our victims and talking to our victim who is a victim of alcohol-facilitated sexual assault, we want to be asking as many questions as we can about, gee, tell me what you had to eat today. What sort of things? When was the last time you had something to eat before you started drinking? Tell me what was your diet. If our offender is using the "I was drunk too" defense, one of the things we want to do so we can get to the truth of what happened is find out from our offender, gee, what were you eating or drinking that day? When was the last time you ate? In addition to finding out things like their size and weight, so we can compare and have baselines to figure out the absorption of alcohol for our victims and for our offenders too. The other factor that's going to be impacting absorption is going to be the impact of muscle and fat on alcohol concentration in blood. When there's fat in a body, alcohol is going to stay in the blood vessels. In other words, fat isn't very water soluble, I think is how you phrase it. So if there's a lot of fat, then the alcohol can't get out of the blood vessel. The alcohol stays in the blood vessel where it's going to be getting into the brain. Where there's muscle, though, which is more watery in nature than fat, alcohol can displace into the muscle. So when that alcohol is then going into muscle tissue or dissipating in muscle tissue after it passes through our small intestine, the concentration in the blood decreases. So the higher fat percentage a person has, then again, there's going to be a higher rate of absorption of alcohol and higher level of intoxication. And actually, our next slide sort of points this out. So if there's a higher fat percentage, alcohol does not leave the blood. It stays in the blood, spikes that BAC up because it's not going to enter fat tissue. If there's higher muscle, then alcohol can leave the blood, won't be accelerating that BAC because that alcohol, it's not staying in the blood for the blood alcohol content and impairing the brain. It's going to be entering muscles. And so when we're talking to victims and witnesses and offenders, we want to be asking questions like, gee, what do you weigh? How tall are you? And we want to make clear the reasons why we're asking these questions is not to invade in an intimate or personal area or be nosy, is because one of the things we want to try and understand is how alcohol could have been absorbed into their body so we can understand and build a case and develop a case and what we can prove. And here's the illustration of what we just discussed. The higher someone's fat content or fat percentage, then the higher the BAC is going to be when they're consuming alcohol. And the higher the muscle content, it contributes or enables a lower BAC. Now, the point we want to draw from this in a lot of ways is going to be one of the, over the next few slides, is hopefully will be one of the light bulb or aha moments. I know it was for me the first time I absorbed this. And we want to talk then about the impact of alcohol on the average male and the average female. And we're talking about averages here, not categoricals. And we also don't want to minimize or forget that males can be victims of sexual assault too. But what we also want to recognize is that more often than not, victims are usually going to be the females are usually going to be the victims of sexual assault. And how most sexual assault is perpetrated, it's going to be in this area of alcohol-facilitated sexual assault. So this is going to be the area where most victims need justice and most offenders are going to need accountability. So for the average male, they are composed of there's going to be 68% water, and there's a higher proportion of muscle tissue compared with women. For the average female, they're 55% water, and there's going to be a higher proportion of fat compared with men. And what this means is, generally speaking, is that when we're talking about alcohol consumption or impairment in men or rate of absorption, generally speaking, it's not a level playing field. This means that there can be an increased blood alcohol content in women for a given quantity of alcohol. And here we have a little formula drawn out that can sort of illustrate this. If you take a male of average BMI who weighs body mass index who weighs 140 pounds, and a female of average BMI who weighs 140 pounds, and assume that each of them consume 6 12-ounce beers over 2 hours, the male is going to have a BAC between 0.14 and 0.15, and the female is going to have a BAC of 0.18 to 0.19. So the female is going to have a higher BAC and predictably greater risk for impairment from alcohol than that average male. But of course, these examples are a little bit unusual, especially if we take something like a college campus where this occurs, because usually the female sometimes might be a little bit lighter than that 140 pounds. The male is going to be heavier. Here's some what might be some more sort of situational type weights and sizes with average BMIs. You have a 190-pound male and a 125-pound female, and this really helps set up the contrast. Assume the same consumption, 6 12-ounce beers over 2 hours. That male is going to be between 0.09 to 0.11 BAC, pretty close to just above the legal limit. When I was started as a prosecutor, that would be below the legal limit for driving usually. To 0.21. And as we talk about the impact of those kinds of BACs on impairment and intoxication, that's going to be a female who's going to be vulnerable to an offender, a male offender who's consuming the same amount of alcohol. That female is going to be vulnerable to a male who wants to perpetrate sexual assault. And because that male is still going to have a lot of judgment skills, isn't going to be sufficiently impaired, that female is, that male offender isn't going to need a weapon because the alcohol has already created that vulnerability. The weapon isn't needed to create that kind of vulnerability. So despite these realities, you really, when you talk about these issues, you really see a lot of double standards that are applicable. And victims might be holding these sort of double standards themselves when they think about it, and this can contribute in one of the challenges for victims disclosing and reporting it. A victim who was drinking, she deserved it. What did she think would happen when she goes to a drinking environment? But as opposed to the offender, when there's a perp drinking or says he was drinking or that it was just drunk sex, he was just some poor drunk guy, you can't hold him responsible. And usually the offender, and what we want to be recognizing or thinking about as we're looking to build a case or the potentiality of building a case, is that offenders know these misconceptions exist. And so offenders, the smart offenders anyway, are going to be really good at camouflage and hiding under and trying to find victims and opportunities to perpetrate where it's less likely they can be held accountable. And so if we can be aware of physiological realities and the reality of toxicology, that's one tool we can use to hopefully uncover this camouflage and show how this offender was using this premeditation and planning to find a victim that was more vulnerable in a way that was a lot more nuanced and subtle than using a weapon or some sort of traditional or stereotypical concept about how sexual violence is perpetrated. So as a central nervous system depressant, here's where alcohol is going to cause intoxication. It's going to be impacting or impairing the brain. And here we have a graphic in as much as we understand the brain, about the different areas of brains responsible for different areas. Brain science obviously is a very complicated topic, and this is something simplified enough even for a layperson like me to understand. And I think most people who are experts or in the science of the brain is, while this is a helpful tool to visualize in many capacities or in many ways, the functions of the brain, it isn't so easy to compartmentalize. Oh, this part of the brain does that. Is that there's interlacing and interacting with one another, and parts of the brain work off other parts of the brain. But what we want to remember is the most developed portion of the brain is affected at lower BACs, and the least developed portion of the human brain is affected at higher brains. So what this means is the most developed portion, that's more the stuff at the top of the brain or the front, the things that make us able to speak, to write, to reason, to write plays, create webinars and things like that, our judgment, our tactical things, those are at the top of the brain. Our speech is a little bit behind that, then vision. And then at the very core of our brain, almost sometimes called our lizard brain, is a part of our brain controlling the things that we don't even think about, our vital functions, our muscle coordination, and our balance. And as we consume alcohol and that BAC starts taking over the blood and that BAC starts spiking up, these portions of the brain from higher functions to lower functions starts getting impaired one by one. What's important to remember, though, is alcohol, as it's impairing our brain, doesn't stop at one area as it moves on to other area. Is our speech is being slurred, it doesn't mean that alcohol is done impairing our judgment and inhibitions. It's also degrading those areas as well. But it's just also expanding or to other areas in addition. So, and I'm not going to go over each of these areas, but a lot of times when we're going to have alcohol facilitated sexual assault cases, even if there's going to be, excuse me, even if there was a sexual assault medical forensic exam, there's probably not going to be a precise BAC available, or that's going to be something we can utilize. Maybe it's because the victim wasn't able to disclose in enough time where it was still, maybe there wasn't capacity for that to be taken during the medical examination. Just because, though, that there's not a lab result for an alcohol facilitated sexual assault case or for a drug facilitated sexual assault case doesn't mean that the case can't be prosecuted. Because what we can do, and with the use sometimes of a toxicologist, which isn't needed for every case, as we'll discuss a little bit later on, but if we talk to enough people and take these cases with the seriousness and thoroughness they deserve, and talk about and ask about the sort of symptoms of intoxication and impairment that was being demonstrated by victims, by offenders, by anyone involved, we can sometimes then compare it to the chart we have here and have an idea, or at least a range of blood alcohol level that they're not sure how little they were eating, height, weight, things of that nature as well. And so going through that. And it's also interesting, well, we'll say that later for talking for an interview about an offender. So the other issue coming up more often than not is also the blackout defense and the attempt to utilize blackouts in which a victim consented when the victim or there's conflicting evidence about a pass out. So one of the things we want to make sure we can understand is the difference and distinctions between blackouts and pass outs, and have an understanding of what a blackout is and versus what a pass out is. Now, what a blackout is, it's a period of memory loss. In other words, the hippocampus portion of your brain, the part of your brain that's forming memories and organizing memories, is so impaired that while memories are being made, they're not able to be cataloged or reached or accessed in any way. There's no loss of consciousness from the person that's suffering a blackout, but they aren't able to access the memories that occurred during the blackout. The brain's ability to form long-term memories from short-term memories is destroyed. Now, when do blackouts happen? Well, it's not just predicted by a high BAC. One of the most likely correlations with people suffering a blackout is going to be if the BAC rises rapidly as opposed to slowly. So suppose someone is out for their 21st birthday and downs 21 shots in an hour. That BAC is going to be increasing. They're a lot more at risk for suffering a BAC. So someone could be at a high BAC of, depending on their tolerance and not unconscious, at 0.25 and not be suffering a blackout. But you could be at a 0.15 BAC and suffering a blackout if that BAC rose very quickly in a short period of time. Now, what's important to remember is that when you're talking about blackouts, and more often than not, when the defense is discussing blackouts, how it's usually utilized by the defense is, well, gee, the victim thinks that they passed out during this period. The victim thinks that they passed out during this period, but in reality, what occurred is they actually blacked out, and they gave some sort of indicators that they consented to whatever the sexual content was. What's critical to remember, though, is when we're talking about blackouts, is the BAC, there isn't anything different or magical in the nature of how someone is impaired by BAC during a blackout as opposed to when they're not in a blackout. And what I mean by this is someone who has, say, a 0.15 BAC and is in a blackout, the impairment isn't necessarily distinguishable from someone who has the same BAC, 0.15, and is not in a blackout. So if we're talking about levels of impairment and how obvious that impairment was to someone else, that blackout defense isn't really going to work if someone was obviously intoxicated and there's evidence of that obvious intoxication. Especially, a lot of offenders are all too happy to talk about how our victims were drunk and intoxicated and acting drunk, except when the moment of consent comes up and they're retelling, then they were magically in control of their faculties. But we want to be finding out that regardless of whether or not a blackout is or is not contended, what was the indication or indicators of intoxication that we can find? And again, even someone with a blackout, they're going to be having a higher BAC. Now, pass outs, this is going to be alcohol-induced unconsciousness. It's sedation due to the central nervous system depressant effect. And essentially, it's going to be a sedated state associated with surgery. It can last hours. And there's a groggy, sedated feeling that can linger for 24 hours. So this is one of the reasons, especially if there's an evidentiary dispute or factual dispute between whether the victim was passed out or blacked out, we want to be able to be asking our victims about how they felt afterwards, physical sensations or physical feelings, because that can be distinguishing or be consistent, more consistent with a pass out than a blackout effect. So we are also talking about drug-facilitated sexual assaults. And what's important to remember is usually drug-facilitated sexual assaults, especially surreptitious administration, while I never want to say never, usually these drug-facilitated sexual assaults, they're happening in conjunction with alcohol. It's usually not going to be an indication where they're independently administered, because usually someone's at a party or a social setting where there's drinking anyway, and that's when the drug is introduced, the drug-facilitated sexual assault can be impacted. Now, these are sometimes known as date rape drugs. I hate that term, so I'm not going to be using that term throughout the rest of this, but colloquially, that's how it's known, and I reference that just so we can have that common reference. These are going to be similar in action on the central nervous system as alcohol, similar effects on the body. The difference is that they, excuse me, act much more quickly and with greater potency than alcohol, and can have that synergistic effect we talked about when consumed with alcohol. Now, the challenge, of course, with prosecuting these cases is that there's usually not any forensics, or they aren't usually detected. And that failure to detect, what we don't want to equate that meaning is that no drug is used. Because one of the things we want to be aware of is that the ability to screen for these substances or test for them is extremely challenging, but it doesn't mean that they weren't utilized. We just have to look for other evidence to build these drug-facilitated sexual assault cases. The reason why these drugs are so rarely detected, or why it can be so often challenging to detect them, is that these kinds of drugs that are part of drug-facilitated sexual assault, they're going to be going through the body a lot more quickly and eliminated. The body wants to get rid of it a lot more quickly than it does alcohol. So that window for detection is going to be really brief. And a lot of victims of drug-facilitated sexual assault, They might not even have an appreciation or understanding that they were victimized until after the fact. So even if they go to the hospital and get tested, there might not have been a window to detect them. This is compounded, though, by the fact that there's a lot of different substances that have been identified as used to facilitate sexual assault. And the trick is, when we're thinking of a test to screen for that, there's not a universal so-called date rape drug test, because there's lots of different drugs. And so if our victim shows up to a medical provider and says, hey, I think I was drugged, it's very hard then to identify what kind of test do we want to use to administer to screen for them. And if you don't use the right screen and the offender used an uncommon drug or a less commonly used drug or a new drug, then it might have been missed. It doesn't mean the victim was inaccurate or imagining things. It just might mean that the system doesn't have necessarily the tools to detect it. The other challenge, too, with a lot of these tests that we have is that the screening levels that are going to be used, the thresholds for detecting these drugs, is there is no uniform standard. So if we have a certain drug that's identified as a drug facilitating sexual assault drug, two different tests might have two different thresholds as to what's used for a positive level. And so there is no universal level. And these aren't the kinds of questions that are always intuitive for us to ask our lab folk or our medical folk too. So when talking about applying our knowledge of toxicology to improve alcohol-facilitated sexual assault and drug-facilitated sexual assault, we want to examine and sort of unpack some tips and tools to better investigate and build our cases. And what, as prosecutors and as any law enforcement folks who are on this call too, we want to listen to our victims, and when they talk about maybe feeling intoxicated in a way that's unusual from their experience from alcohol, that didn't feel like a normal drinking or not consistent with the amount they drank, these are warning signs to us that maybe some sort of drug was used and used without our victim's knowledge. And so we don't want to assume that even if there's no testing, or even if the testing shows negative, it doesn't mean that there's no prosecution or that we can't go forward. Idea to have our sexual assault nurse examiners or sexual assault forensic examiners draw blood for a toxicology screen unless a drug is indicated and it's still within the window of the detection period. Because the reason why we say that is because if we don't think it's in a case, and the reason why we don't want to do these screens just as standard practice, is if there's no basis to suspect, we could be exposing privacy issues for our victims and issues that aren't relevant to analyzing their credibility and invading that and making it harder for them to participate in a prosecution. So I'm going to be shortly handing this back to my colleague, Patty Powers. But before I do so, we want to talk about when to call a toxicologist. And even when they can be really great during an alcohol facilitated or DFSA case. But we don't always have to do it as a standard of course, because as we're going to talk about, and Patty's going to talk about a little bit, sometimes our medical folks can explain these issues. Sometimes our law enforcement folk can explain these issues. And we're asking our supervisors for the money to do that. We want to have a specific reason to doing so. In other words, if we have a DFSA case, but no negative tests or no tests, we might want our toxicologist to start talking about some of the symptoms, what kind of drugs, that sort of symptomology that the evidence illustrates what sort of drug that's consistent with. When our defense is using a toxicologist, though, that's a really best case scenario, because we can really drive home these points with a lot of the information we talked about in our case. And that's this. And this serves as a pretty good summary for some of the big takeaways we talked about in this toxicology piece. That alcohol, it's a central nervous system depressant. It disproportionately affects women, excuse me. There are visible manifestations of intoxication, that it's not a hallucinogen, which is important if our victims recall or remember saying no. Only the passage of time removes alcohol from the human body, not startling events. So a lot of offenders and a lot of jurors hold the conception, well, gee, if I was being sexually assaulted, the shock of that would startle me out of intoxication. And that's just, that's just not real. That's a myth. And also our toxicologist, any toxicologist is going to be able to establish that a retrograde extrapolation, if they have a known number and a history of drinking, and that it can also cause lack of judgment, impaired judgment, and other matters which we've discussed. So I'm going to hand things over back to my to my incredible and amazing colleague, Patty Powers.
Thank you so much, John. That was great. And I know we all learned a lot from this part of the presentation that we can apply in our work. You know, we're getting some great questions and we're going to do our best to incorporate those. If, however, we don't get to all of your questions, and we'll do our best, please contact John and I at Equitas. We would be honored to answer your questions and support you in any way. One of the questions that has been coming up and almost constitutes a theme is, what do we do when the offender was drunk too? Or who has control when the offender is drunk? Before we get into this next part on proving the victim's level of intoxication at trial, I want us to carefully consider the defense claim of drunk sex, or the defendant was drunk. We've got to really examine that. And it means let's talk to secondary witnesses. What was his conduct or behavior like? If this was in a bar, then we want to take a look at the tabs that were involved, look what his signature is like, and essentially follow him through as much as we can, applying toxicology to our consideration of his conduct. But we don't want to accept that claim without a deeper dive into the evidence. And I'll try to pick up on that again. But what we're focusing on now is proving the victim's level of intoxication at trial. And some of us who are participating may have at an earlier point in our career had experience with DWI, or driving while intoxicated cases. So let's turn to some of the ideas that we can generate from that field of practice. Think about the DWI or DUI evidence that's very commonly used. There's an odor of alcoholic beverage. Sometimes a person's eyes will be bloodshot or watery. Maybe they're not talking so that they can be understood, fumbling or having some difficulty in balance. They're asked to do something like sign a bar tab and cannot do that, or to engage in some other conduct, and they're basically unbalanced and not coordinated. We can look at some of these vestiges to help give us information about a level of intoxication when we may not be able to extrapolate back, where we have insufficient evidence to do that. We can still look at some of the physical and behavioral aspects. So these are some of the factors we're going to take a look at. When was the victim drinking? You know, was this earlier in the day? Was it during an event and prior to the sexual assault? We try to isolate as much as we can this part of the context and try to determine the beginning of the consumption of alcohol by time. And another question we want to find out is, what was the victim drinking? Are we talking about beer? Are we talking about wine? Are we talking about shots? Are we talking about mixed drinks? But we also want to try to get that information as much as possible as well. What is the period of time of the drinking? And this can be interesting sometimes. Sometimes individuals will drink earlier, then they may have something to eat. There may be another lapse in time with additional drinking. So what we're really asking for in terms of information is the continuum or the development of drinking throughout whatever the given period of time is, as best as can be provided. Evidence of extreme intoxication might be featured with some of these bullets that we're all looking at on the screen. Was there vomiting? Sometimes a person can get sick while they're drinking, but many times there's going to be every effort made to try to get to a more private place or to get out of a social scene if a person is feeling ill that way. Was there involuntary urination? The victim's walking. If anyone has watched the victim perhaps go to the restroom or go out to her car or talk with someone in another area of the event, what was that like? Secondary witnesses who may have spoken with the victim, did they notice anything different about the victim's tone or the victim's ability to understand things that they were saying or to be involved in a conversation? Now, this next bullet is kind of interesting. Did the defendant carry the victim? We also need to look at this from the offender's predatory point of view as well. It may be a victim is becoming intoxicated and the defendant uses that as an opportunity to exercise this kind of control over the victim. So we need to kind of look at what's going on in the context of this event. Then where did the sexual assault take place at? Was it at an event but outside of the site, or maybe not the hearing range of other individuals? Was it in a motor vehicle? Where did this happen? And then, of course, we want to know whether the victim was conscious. And John did a great job earlier about talking about blackout versus pass out. And that's invaluable information to apply. But one of the things that we also need to consider is how the victim is using that language. A victim may use blackout when she really was unconscious. Sometimes victims will use these words interchangeably. So if a victim tells us that she was unconscious, for example, then we're going the last thing that she remembers, what is the next thing that she's able to describe to us? If a victim states, perhaps incorrectly, that she was blacked out, we're going to ask the same set of questions. Sometimes even professionals have used those terms interchangeably. So we have to be careful, again, with the language that's being used and go the extra step in asking what that experience was like, as we've discussed. Some other focal points. Did the victim have to be assisted with physical tasks? And again, we need to look at this. What task is the victim performing, or would we think she'd be performing? And what's the offender's role in it? Sometimes we're also going to see some of that control factor exercised as well with the victim who is affected by alcohol. Who undressed the victim? Does the victim have a recollection of this? Did the offender carry the victim? Again, look at this not only as proof for the victim's level of intoxication, but look who's entering the picture. Look at the offender's use of control in this area. What was the victim's appearance like? And in this area, we can turn maybe witnesses also saw the victim at a tavern, as an example. Was there any disruption in her clothing? Did her hair and other parts of her physical bearing appear different? Was she disheveled at all? If a person is close enough to have a conversation, was there anything about the victim's eyes that drew their attention? So these are just features that may support better our understanding of a victim's state of intoxication. And also go back to the clinical chart that John was discussing earlier. That gives us a lot of information about the different levels of alcohol. And sometimes we can take some of our behavioral observations or secondary witnesses basic pictures of different aspects of the victim's presentation and really come to understand where that victim may have been at clinically. Sexual acts and positions can also be important, again, as a feature of an offender manipulating a victim who is seriously intoxicated and is unable to consent. So this is some of the corroboration that I was referring to earlier. The secondary witnesses are important. Witnesses that saw the victim before the crime, perhaps even during that period of time, and then afterwards. The crime scene is important too. And as prosecutors, we know that these crime scenes need to be very carefully investigated. We're looking for evidence that is going to support just about every aspect of the victim's statement. Some of these may be more minor points of corroboration, but all of these points become critical when we are providing a jury with evidence of what the victim has said as to the time, the place, any evidence that was present during that context. They're all important. Evidence of trauma. Evidence of physical trauma can be important, but evidence of psychological trauma is also important. A victim's disclosure to a friend days after the assault can be an important feature of trauma and can help explain how a victim was unable to describe what had happened to her because she was literally trying to come to grips with what the offender had done. Digital evidence. We see a lot of this in just about all of our sexual assault cases. There can be the use of social media, there can be photographs, there can be videotapes, but digital evidence should certainly be considered in terms of an investigation. Medical evidence is important also if the victim has been able to disclose and seek a medical evaluation from a sane or other qualified medical professional. That statement for purpose of disclosure, the statement for purpose of medical diagnosis, is also a very important part of the evidence that we'll be presenting to a jury. Sometimes expert testimony. The toxicologist can be important. A sane can testify also. Sometimes behavioral experts can help answer questions that a jury would have based upon the victim's response to trauma. Secondary witnesses, again, and some of those witnesses may be the victim's friends. It may be an offender's ex-girlfriends. It's amazing how much information we can obtain from not only ex-girlfriends, but also even associates of the offender. It's interesting how many individuals who know offenders are concerned with giving law enforcement an understanding that the offender was very intoxicated. They may even say, well, he was doing okay. He was in good enough shape to drive her home as they had planned. So make sure that we're unturning all of those stones in terms of accessing these witnesses. Bartenders who have a responsibility and also may have liability for serving drinks to individuals who may have consumed too much, may have information, as well as other individuals who are present. If a cab or an Uber or a Lyft was called, then these individuals may also be able to provide important information. So in terms of physical evidence collection, these are just a few of the aspects of physical evidence that can be very important. If the victim suffered any kind of an injury, whether from falling, for example, or being rammed into an area of the home, then we want to document that blood and make sure that we're taking a sample of it to establish whose blood it was in the event that this is probative and we want to present it at trial. If a victim's hair was pulled out, or if she lost some hair due to her situation on a couch or on a bed, we want that. Urine samples should be taken if a victim, or If a victim lost control of her ability, and urinated vomit can also be a source of DNA. My apologies if you're watching this during a period of time when you have had or are going to have lunch, but this can also establish the level of intoxication, circumstantially at least, and also we can develop DNA from that specimen. Semen on the sheets, on the couch, on the floor, wherever that was, should be taken into our custody, as well as sheets if the sexual assault occurred on them. The victim's clothing is also important, and if the offender left any clothing behind, we certainly want that as evidence as well. A condom, whether used or unused, if it was left by the offender, is something that we also want to consider. If there were surveillance tapes in an area, we all know as prosecutors, we have to access those as quickly as possible. So many times in cases that we've had or consulted on, the request hasn't been made that quickly, and sometimes individuals will record over the tapes or discard them. So we want to try to get those quickly. We already talked about social media and cell phones. This can have important information. If we're going to be asking a victim to review the contents of her cell phone, we have to be keenly aware of privacy, of victim privacy, and potentially releasing this to discovery. So we have to be very careful about exactly what it is we're asking for when we ask the victim's consent. Glasses, punch bowls, beer cans, bottles are also important, may have fingerprints on them, or even if not, can help us document the disclosure, and also provides more in-depth understanding of that crime scene. At a bar, if there are receipts or credit card charges, we certainly want to get copies of those and actually take a look at the offender's writing. And we can certainly compare it with other writing, and it may just be that the offender was doing just fine, even though he complained of being intoxicated. Pretext phone calls are a great idea, but in the right case. We want to review the law in our jurisdictions very carefully to determine if we're able to do that and how we're able to do it, and to plan it carefully. If we're going to be asking a victim to engage in a pretext call or be involved in a monitored meeting, we need to make sure that the victim is able to do that, that it's not going to cause additional trauma. If the victim wants to have an advocate present, that is something that should also be arranged. We need to be very careful about the content of the pretext call and what we're asking the victim to say. You know, that the content of that call and what the victim says, this information is going to be provided to the defense in discovery, and it certainly can be used by the defense. Even in a case where we're asking a victim to say that she enjoyed this encounter with the offender and enjoyed what was going on, be very careful about how that can be used in a trial by a defense attorney. Well, you stated when you spoke to my client that you enjoyed this. We may be putting the victim in a position where she needs to explain. And there are other examples of this as well. But what we want to do is to carefully consider if this is in the best interests of our case, and it's also in the best interests of the victim. The offender interview, this is what we look forward to, and we want to make sure that law enforcement conducts this interview if the offender agrees to do it. It should always be attempted. How many times have we had cases where it wasn't? And we always look back and wish we could have had that initial information. We want the offender to provide as much information as possible. And what we're also looking to is for the offender to corroborate specifics of the victim's account. And in that interview, we're looking for the switch. We may have the offender saying, well, she was just completely drunk, and I don't know why she's making this up about me. Maybe she's crazy. And then later on in his interview, we have him saying, look, it was clear that she wanted to have sex with me. So we're looking for that kind of switch, if you will. If an offender is going to provide information about why he believes that the victim is making that up, that can also be useful to us. We also want to ask the offender a lot of questions about who made the decisions, who called the shots, who was in control, whose idea was it to go out that night, who selected the place where you were going to go. Well, who ordered that pitcher of beer? Who ordered those drinks? Who decided that it was time to leave? Who decided that he was going to drive the victim's car? Who was the one that decided that he was going to accompany the victim into the home? And this can be useful and fertile information for cross-examination as well. And then again, and I think we touched on this earlier in response to some of your questions, we want to focus on the offender's abilities despite drinking. He may want to paint himself as drunk so that he doesn't have responsibility for this crime, or he may want to paint himself as chivalrous and only doing his best to assist a victim who is intoxicated. So we've got to take a deeper dive into the evidence to really understand predatory conduct. Remember, if ever there were a formula for predatory conduct, it's this: accessibility, the victim is right there. Vulnerability, how much more vulnerable can a victim be than a victim who is impaired by alcohol or is substantially incapacitated? And then that third component is credibility, not how you and I think about credibility. This is how the offender does. The offender believes that a jury or a community are not going to believe a victim who is drinking. We know better. As John said earlier, it's not an even playing field. But with our deeper dive into this evidence and accessing experts in toxicology, we can portray a fair picture to the jury. These are some resources that we have for you available at Equitas. You'll also be able to access this webinar, and we have other information as well that we'd be delighted to provide to you. Going forward, we want to take the information that we have about toxicology and apply it from the beginning to the end of our work on alcohol-facilitated sexual assault and drug-facilitated cases. Our ability to conduct comprehensive interviews, to do investigations that are focused on the fullness of evidence available, really starts with this basic understanding of toxicology. We want to focus on the offender. We want to employ offender-focused themes. As we discussed just a moment ago, who had control? Who made the decisions? Who called the shots? She was vulnerable. He exploited that vulnerability. And clearly, he used that vulnerability to facilitate this crime of drug and alcohol-facilitated sexual assault. I want to thank you so much for your participation today. We haven't been able to get to all of your questions, but if you'll maintain contact with us at the office, we'd be very happy to answer these questions and provide you any additional support. It's been a pleasure being with you today, and I want to wish you the absolute best of success in all of your work as prosecutors and allied professionals.
So just to sort of cap it off, I want to provide everyone with some of our contact information, because as I was trying to listen to Patty's great information, trying to get to some of the Q&A that's still open. Not sure we had time to get to everything. Hopefully what we did offer was helpful, but here's contact information for Patty. And just because I don't want you to default to her, let me give you mine too, which is right here. Please reach out to either of us if there's any assistance we can provide, or if we didn't get to your question, which we apologize for. Our ideal is to get to every question. Also, I know some of the content we're going to be talking about next week in part 2 of alcohol-facilitated sexual assault, which is on Wednesday, May 20th, same bat time and same bat station. If you haven't registered for it, please do so. I don't know if registration's still open, so maybe I shouldn't have said that so quickly. But I want to thank everyone for participating in this and for being such an attentive, fantastic audience. Thank you so much. Take care.
Stay safe.
Stay safe. Yes, here, here.